Okay, good morning, ladies and gentlemen. In this week, I'm called to report early in the morning, so I must say good morning, then good afternoon. So, weekly, I expect you will monitor the videotape lecture. So, I occasionally visit to check out for class purpose about your attendance. And please make sure you will not miss any previous lectures series. Okay, in this class, we'll discuss informality and formality in administrative law. So, and further, we'll consider the U.S. court system. Typically, the selection of federal judges, a political influence will not be less in context. So the political ideology is also could be one factor in shaping the public policy in the United States. So that would be the content we expect to explore through 2 hours class. Then we also retrospect federalism or Department of Commerce Clause in its implications about public policy in the United States. So actually, we have a 2 line authority, and in response with a dual sovereignty, federalism in the United States, so state court system and the federal judiciary. So you will see in a website U.S. court system and other the selection method about the federal judiciary and state court judges. The selection of judges would often be a dominant process politically. So the state you see, for example, qualification of court judges, and also the method to select them. Most of a state jurisdiction, they utilize a popular vote, so popular election and general election. Well, in some cases, rarely, however, at the pledge of Chief Justice, the state court system is very ordinate over 58 jurisdictions, as you consider. So I failed to result the website. You will helpfully refer to what they did. Page a pertinent, so a Supreme Court and state code, appellate code, and district code. In some cases, gubernatorial appointment through nominating commission would be one way to formulate the state forum. And I accepted one map which shows the geographic boundaries about a federal code. 11 divisions, geographic divisions may be conformed. You see what the largest province would be 9th Circuit, And added to this basic distribution, you consider two special core systems. So we have 13, perhaps 13th circuit code. Please confirm the number. And also over 90 district codes were now in section to respond with a role and responsibility. You will know the Supreme Court organization, perhaps 9 justices. The number would have changed, must have changed historically. You see, until the mid-80s, only 6 Supreme Court justices who served the position. It rose to 9, perhaps in the mid of 19th centuries, and very selected few. Are they invincible Marines to maintain the federal system? So consider in comparison about the number of key officials of the United States. 50 states, then we have 100 senators and 50 governors, and perhaps several thousands of representatives from the House. Then the number 9 means very influential, and a selected few actually, and often central organ to maintain the federal system of the United States. He or she would a pedantic quibble, or they actually a highly nobility to argue on important national agendas. Is very also selective in jurisdictions, perhaps via the instrumentality of a certiorari. So probably over several over 20 or 30,000 petition for certiorari, but only perhaps 200 or 300 cases only be granted a certiorari. So you will see a limited ambit about its case roles. For example, if we stick to pure number of review, however, the Supreme Court would be assigned many important duties and responsibilities. For example, respective Supreme Court justices are assigned with a territorial or provincial responsibility about judicial conferences. For example, they lead the legal intelligence in some dimension. So they and also officially be responsible with the cases or controversies which are rise from respective province. They are responsible for. And you may have chance to visit the website of Supreme Court, and they publish what official case report. And, we have a high extent of technological advances, so online availability could be certain, you see. And also the court calendar made public about the conference days, for example, or the session days to discuss the actual case. Often they work on a written basis. They seldom hold the oral proceeding, and in some cases they summon witnesses or expert testimony in dealing with difficult questions. And also they would undertake a scope of assistance. What is amicus? Friendly circle, who are friendly circle to aid the Supreme Court. The academia, for example, may file their opinion about the question or specific issues. And the federal or state government also assist with filing fact declarations, for example, and their opinion. So the proceeding actually undertaken in the Supreme Court of the United States are highly conservative, but actually might span wider spectrum as available as possible. But the selection of federal judges would be in high certainty, you consider. As I said, judges or justices often politically elected over state courts. Nonetheless, the federal judges would be appointed. You know, the constitutional mandate about appointment clause conferred on the President of the United States. On the basis of that clause, President would nominate the candidates for federal judicial post, and the appointment power has to be checked, as we know. A Senate approval would be essential to make it effective. And the Department of Justice would be an important organ to advise the proper and adequate selection of candidates. About the federal judgeship, there is no formal law or regulation except for the Constitution. So it is open to the leeway of a president and their staffs or aides. However, the nominating commission organized within the Department of Justice would develop some informal standard or process to select the proper judges. And also the Senate would be provided with a nominating some special Commission to respond with the nomination from the executive. Once we have some example about their practices with Song Kim as a diplomat, and we heard that their approval process was delayed. You may see some context of delicacy about the partisan politics. So Republican or Democratic Party would be a major party. You know, other parties as fragmented. For what a peace, Greenpeace party. What is the party name? A Constitution party. So and non-affiliation. Actually, two major parties have dominated of history. So the political ideology often attributed to major parties would may compel them go their own way. Yeah? So you know, filibuster, for example, what is that? Is kind of constitutional practice. Of course, not in contradiction with the express language of Constitution. So, some area permissible without any mandate. And actually, that is the element that the political branches would be expected to behave in that way. So the Senate Approval Committee may strategically procrastinate the process of appointment, for example. So many, in some cases, they might be legitimate to reject the nominee. So it is also important matter as similar in the Korean politics. See, if the Senate or House of Representatives were in weaker status with respect to political dominance, so they may fail midterm election, for example, and the final words may well be split between the executive and Congress. Then the national politics would face with high chances of disruption. Perhaps same in the Republic of South Korea and other countries that could differ depending on what structure of government were employed or actually practiced. So the selection of federal judges would be influenced politically and in accordance with the partisan politics. And that is also a corollary dominantly from the spoils system. One example what in covering the judiciary, and typically it also has high implications since the judicial authority is important instrumentality in shaping American public policy, as I've reiterated. So, for example, let us consider some examples. What is that? You will see student First Amendment rights and the federal judgeship. It was accepted from one article which undertakes a empirical study about the correlative between political ideologies and attitude of the federal judges. What is First Amendment rights? Search and seizure should be shaped and also implemented based on the constitutional provision. So should be warranted about human rights ideas, you see. And student is not actually mature in many instances, and they would be a class of people who should be perceived in a view of educational aspect. What is it? They are now growing, and properties would be considered in other way against the adult waters. So what is that? A strip search might be obvious to be turned down if we consider its legality. In other case, however, that extreme measure may be permissible when we assume some extreme situations about a allegation of important crimes that the students have perpetrated. For example, in some cases we have see proper. So actually, the incident could be imagined, for example, a locker room search and body search, in extreme cases, a strip search. And how to understand the permissible scope of a Fourth Amendment in the case of student is one important policy issue in the American legal system. What the kind of issue would have a same attribute. I generally suppose the private and public dichotomy could pertain to that discussion, and the social and in some cases familial area is most intense, which is subjected to the political ideology of judges. The conservative judges would be from a Republican Party, we generally believe, and progressive, would be staffed perhaps by Democrats. That could be basic in our apprehension, or consider. And also the concept of liberal conservative or liberal progressive. Do you consider any differences between two concepts, and one negative liberty, a positive liberty, and the kind of basic terms we consider philosophically the modern civic virtues. A small government. Perhaps one interesting statement from Ronald Reagan. The what you may recall, the government is not a solution of a social trauma. The government is problem itself. So President Reagan, in his tenure term, focused on a small government and actually intended to force the autonomy, social autonomy, in dependent for each institution. A school might subsidize themselves in their own initiative, in their own capacity. The federal government would intervene highly in a small ambit. Yes. So autonomy may profile high, and also small government and the state capabilities would be seen an essential generator of a national productivity. For example, they also envisage in scope of a policy area and a ordinate big government is also one propaganda that the former President George Bush launched in ensuring his candidacy. And so in that concept, negative liberty will be on soil to be bred more actively. And actually, how do you see the concept of positive liberty? Once I have commented on philosophers, or the proud of Aristotle. So what is actually a justice, social justice? So we have been bestowed with different talents or capabilities, and so structural element of society system would aggravate its innate injustice, for example. So how we can make individuals and citizens to be based on his capacity would be a central theme we need to endeavor when we think about a social justice. The concept of positive liberty may be embraced in that aspect. So how do we reform or moderate the social levels from a structural injustice? How they perceive. And the progressives would like to engineer in that adherence, and they have one influence to step the sprinkled justices. Of course, the normative context, but the normative demand essential in since its judicial post is fairly prevailing, so they share basically the ideas which might often conservative consider. However, the ideologies could be built, and actually the empirical study, the surface of empirical study, suppose the high correlation, high correlative between appointment and the attitudes of federal judges. Often they are loyal and faithful to the party's position of a appointing president, and the party his or her partisan affiliation. And we consider, for example, what is that? The situation where the student should be responsible to the discipline board proceeding, for example, that he or she may disrupt class, and fighting would follow to alter the basic educational purposes of a specific class. And so he should be accused and might be expelled from the school, and expulsion might be emphasized. So since it is highly serious, then what extent of a hearing should be afforded to the kind of a student in predicament? He is a boy of small age, or so what I have commented, the extent of a due process protection is the kind of issue about the expenses of government. Well, actually, we could not be competent cases, and often the financial resources could not satisfy all the required due process. So practically it has a limit, and in some cases exceptions. And informality of a agency's action in one example you consider. And how do you distinguish a disciplinary hearing from some academic failure of medical student? The case we see later would involve that aspect. So perhaps we see a more general standard, when we define the scope of a school authority. When they engage in academic matters, the school deserves, actually, in the court viewpoint, more leniency beyond any strict legal requirement. So, however, we will see a difference when we consider the matter in terms of a discipline, the kind of the whole betrayal to disrupt the class orders, And I also intend to show some difference between informality and formality in administrative law. As the rule of concept, law concept governs in this class, you see the state rulemaking or judicial process should be formal. It should comply with the Constitution and administrative law, or the APA, other specific statute they are assigned to implement. Surprisingly, we see a scope of an informal area. The administrative agencies would often make their way. So actually, I have said the aspect of sagacity. So they are left with the scope of spaces they have to fill the gap. They have no definite mandate in many instances. Let us illustrate examples of informal administration. For example, what a Federal Trade Commission, they may detect some abuses and intend to eliminate them in the undertaking businesses. They may weigh in two ways between a judiciary strategy and a rulemaking strategy. They may charge individual violators with unfair business practices through no-shows. So, and they plainly put them to jail or impose fines since they violate the laws. They also may plot to craft rules to respond with that evils, they write rules and apply them to all undertakers. So what strategies could be implemented? That would be decided informally. It falls within the entire within the discretion of Federal Trade Commission. So no definite mandate would travel the action. So many ample ways, and you also will be reminded of a Chevron rule, and the court also will respect the exercise of discretion. They would only be forced in the case where they consider it serious, and so impermissibly deviate from the scope of a leniency granted in the administrative law. And what is other informal case? A hospital reports to state health agency, for example. What you may hear of botulism, toxic poisoning, and a patient has suffered from the toxic poisoning. Then how do you perceive that situation? The hospital traces the offending organism to certain brand of canned meat, then the state health agency will be competent to pull all the products from groceries all together, pull all together from the shelves of grocery. So that would not be predicated on further investigation or other formal process provided by pertinent statute or APA. So it is one informality. And consider the illustration involving Internal Revenue Service. You may know some tax institution, what is deductible business expense. It's actually a difficult area of law. And the taxpayer may claim the cost of operating which formally classed as a deductible in terms of a internal tax. And we also have a different classifications between estate and personal tax. However, it is not statutorily provided, and nor any definite. So it could be disposed in any discretion by Internal Revenue Service. They may decide to shift the personnel from the review of estate tax returns to the review of income tax returns. And also consider tax-exempt status. Christian coalition, which might be a famed organization. It was once headed by Pat Robertson in the actual case. Throughout the 1990s, the organization was granted a tax-exempt status. However, the law requires that the organization should not engage in political activities. Otherwise, it was disqualified for the tax-exempt status. Pat Robertson himself had run for the Republican presidential nomination in 1988. And the coalition vigorously supported Oliver North in his Senate race against Charles Ruff in 1994. So, actually, the organization would not be due to qualify for tax-exempt status. So, the controversy may embroil in due consideration, you suppose. What is the situation that the agency would undertake deal with? So they could be determinative in some sort. However, the process would get further lengthier by exchanging informal negotiation, concession, and other. And often it is one of administrative techniques, as we have surveyed. And the organization actually petitioned for the exemption, tax-exempt status. With an extensive exchange of contact communication, actually the organization withdrew the petition. that is because the organization knew it would not be approved eventually. And that is one illustration also. And you consider some allegation about sexual abuse, sexual harassment in the workplace. It is important public agenda now in sensitive attention of the nation. Well, actually, the sexual harassment in the ranks and the campus would pose public challenges. How do we consider serious and also so many elements need to be discussed about that issue. And then female administrator may report to her head of division. So what is that? And the division head tells her not to worry about it, because you will speak to her supervisor informally about the matter. The division head goes to the supervisor's office and discusses the complaint against him confidentially. The male supervisor agrees to stop the behavior. So Heidi is quizzing for the female administrator to carry a career in the Department of Justice. The head of division might explore many possibilities, alternatives. He can respond with. One option was adopted, and he actually decided to settle via informal communication and others. And he or she may bring the case to the courtroom, for example, he may undertake a harsh measure, Title 7 of Civil Rights Act of 1964. So it actually a statute to safeguard the federal employee of a rights, various scope of rights, and may bring legal actions, in this case against the supervisor and the Department of Justice. The head decision to talk informally to the male supervisor about the complaint are very informal. So you now know a reality of a administrative action or any disposition about the specific cases would tilt on rather informality than formality. We see some insightful comment from Chief Justice Oliver Wendell Holmes. The existence of body of authority and formal procedures that may be invoked when necessary. But it shapes informal practice, even as they will reside in the background as a kind of a brooding omnipresence in the sky. brooding omnipresence in the sky. So you now sorry to disrupt you. Okay. Sorry to disrupt class. So you can see the cases about the legal problems which arises from informal administrative rule-making or adjudication. One interesting case you may learn of our routines. For example, we have a vast number of farmers or agricultural business in the city. In some cases, they have collaborated with government agencies. They may be assured of any success in planting seeds or others. And what about the ignorance of laws in the context of its legal consequences? The public officers may also not knowledgeable in details about the requirement or scientific standard. They may give a wrong advice in some cases. Then do you consider it warrants any liability in the ambit of a compensation? How do you consider the government should be responsible about this wrong advice? We may apply some private terms involving private insurance enterprises. Often, the government may run, in some cases, which is public nature, however. So it is kind of a law and statute, objective and impartial to be applied over all cases. So the liability scheme would not be easier, and actually, for example, this kind of estoppel cases, like Merrill, you see later, raise the ancient problem expressed in the maxim. Ignorance of law excuses no man. If one did not turn scare corners, then farmers who lose uninsured crops can falsely claim that someone on the phone told them they had insurance and succeed. So it might lead to expand what unimaginable amount of a government budget, for example. So the code would not favor the ignorant public of a farmer or others. He should refer to scare corners. They are responsible to conform their duties and rights more specifically. How do you see? The criticism would not be less. The opposite result from the one which the Merrill does encourage fraud. But other cases arise in which estoppel seems manifestly unfair to the aggrieved person. The farmers in Merrill presumably would have planted anyway and taken their chances, so their losses are not altogether in the hands of government. But what if a governmental official explains the law accurately to client and then says, but you waived the law in your case? Following the decision in Hacker versus Community Health Services, some commentators see a small relaxation in the standard. So you now may have a standard, articulated neatly by Stephen J. Kane. He says that as long as the party is actually made worse off because he or she relied on government advice, and the party did not act simply out of ignorance of the legal rules applicable to the case, then the party may recover. Then let us ask, is it possible the courts, perhaps because they are part of the government, become protective of the government in cases where people claim the government erred? We later consider the liability of government, a toll scheme, or in coverage of class. Okay, we'll take 10 minutes break. I'll return as possible.